Neil, interpret what this means for us.
Well, I think your viewers all recall that Donald Trump, while president, blocked a lot of testimony from executive branch officials using this doctrine called executive privilege. And executive privilege has a long pedigree. It's used for all sorts of reasons to provide secrecy around government decision making, usually at the time, because you don't want basically courts or Congress meddling in the midst of like foreign affairs decisions or military decisions and the like. But executive privilege is always waivable. And what the Justice Department today has said with President Biden's support is that executive privilege shouldn't be used here. They make really the most common sense, obvious point, Lawrence, which is what we are talking about here is the former president weaponizing the Justice Department in order to advance his personal political interests. That's the language you just flashed on the screen a moment ago. And that's a pretty extraordinary accusation to make against a former president. But here the Justice Department is saying, look, that's a serious accusation, and we think the American public and Congress deserve to know the truth about what happened. And they should hear from Justice Department officials and former Justice Department officials in the Trump administration. Those folks should tell their story to the Congress about what happened.
But it seems like the language here is rather mild. They're saying advance his own personal political interests. It also could be described as election fraud. It could be described in criminal terms. It could turn into a criminal investigation, couldn't it?
Absolutely. And the Justice Department, of course, is not going to tip their hand on a letter like this and use criminal statute language now, because, that's something that they will speak through an indictment if that becomes appropriate. But honestly, Lawrence, I actually read this language and thought, wow, this is the kind of strong language I've been hoping from the Justice Department now for, almost a half year. I mean, a part that you didn't shows that the accusations that Donald Trump conspired with the Justice Department official named Jeffrey Clark to possibly overthrow the election and the like. So there's a lot in there that is really, really serious. And so now those former officials will have to testify, and possibly under this opinion, Donald Trump himself may have to testify because he doesn't have executive privilege. He can try and claim he owns it and so on. But the Supreme Court has said executive privilege is for the incumbent, not for past presidents.
But presumably Donald Trump will eat up some time in court if he is subpoenaed. And many of these other possible witnesses might also eat up some court time if they are subpoenaed.
Donald Trump will certainly try and eat up court time. That's all he knows what to do. I mean, he doesn't know how to tell the truth. And so he will invoke with every possible defense all of this stuff. My only point to you, Lawrence, is it's going nowhere. The Supreme Court precedent on this is very, very strongly against him now that the Attorney General and the White House has made this determination on executive privilege.
Another decision by the Justice Department on the lawsuit suing Mo Brooks, Congressman Mo Brooks, for inciting the Capitol insurrection. Explain that one to us.
Yeah, this is a big deal. So there's a law called the Westfall Act, and it says you can't sue federal employees if they're acting within the scope of their employment. And in this lawsuit, Representative Eric Swalwell, a frequent guest on your program and this channel, sued Representative Mo Brooks, saying, Brooks, you basically conspired to foment the January 6th insurrection. And get this, Lawrence, Brooks's defense was, no, what I did was in the scope of my employment as a member of Congress. And what the Justice Department today said is poppycock. Fomenting a coup turns out not to be in the job description of a member of Congress, and organizing an attack on your employer is not within the scope of employment. So what this means is that while Brooks can still try and argue this Westfall Act stuff, the Justice Department has come in against him, and he's likely to lose it. Now, Donald Trump is also a defendant in this lawsuit, and he's also invoked the Westfall Act. And the Justice Department today didn't say anything about that. I suspect they will in the days to come. There is some language in the opinion today, in the decision today, the brief that they filed, that suggests that they don't believe Donald Trump has any Westfall Act immunity, but that's going to be the subject of a separate filing later on. But these two decisions today are pro rule of law decisions, Lawrence, that basically say Trump and his minions, the truth is going to come out. These folks will be held accountable.